Good afternoon. Welcome to Stir Talk for this week, this month. On behalf of the Schmid Law Library, it's my pleasure to introduce today's speaker, Professor Kristen Blankley, who is a repeater. I think, is she our first repeater? So we're very pleased about that. Today she's going to talk about arbitration preemption. I think that's fully apparent up there. Professor Blankley came to us in 2010 from Squire, Sanders, and Dempsey, where she practiced in a wide variety of civil litigation matters. She graduated of The Ohio State University, where she graduated first in her class. Served 2 federal clerkships in 2 different circuits. A neat trick, and ultimately she went into practice and now teaching. Her litigation career at Squire Sanders taught her a great deal, which obviously led to her current specialty and interest, alternate dispute resolution, which is completely designed to keep people out of court, out of litigation, right? So she learned her lesson well. But you may not know that Professor Blankley is also an accomplished singer. She sings with the rock and roll band, sings at Salt Dog games, the national anthem, and at graduations. You can catch her all over town if you keep your eyes peeled. But she's not singing today. But please welcome Kristen Blankley.
Thank you. Thank you very much. I'm glad to be here today and to talk to all of you about a subject that I have been dealing with almost every day for nearly a year. The way I got to this subject is I had kind of quipped with some of my colleagues at national conferences. I say, oh, you know, the Supreme Court, they seem to be applying conflict preemption in the area of the Federal Arbitration Act, but it feels like field preemption. And that kind of made me think I should look at this a little more deeply. I want to start by talking about preemption generally. I know this is a subject of great interest, but okay, so classic preemption doctrine. We generally have 3 different types of preemption. The first type of preemption, and all of these types of preemption stem from the Constitution. They stem from the Supremacy Clause of the Constitution. The Supremacy Clause says that the Constitution is the supreme law of the land. And so what that means is that it will override state or municipal law to the contrary. Congress can do this, can create a preemptive effect in one of 3 ways. The first way is when Congress says in the statute, this statute has preemptive effect and will apply and will displace state law to the contrary. One example of this is in the context of ERISA. There is a statute, there's a section of ERISA that says it will apply in state and federal law. The second area is something called field preemption. And this is where usually it occurs when there's a broad grant of authority to a federal regulatory agency, and the combination of statutory law plus regulation so permeates a field, so occupies a field that states are not prohibited from regulating at all within the field. Interestingly, when you have field preemption, states are not permitted to regulate at all, not even consistent with federal authority. The third type of preemption is something called conflict preemption. This occurs when the federal statute and the state regulation are in direct conflict with one another. There are generally 2 tests that apply. The first test is whether it is a physical impossibility to apply with both the federal and the state regulation at the same time. If there's a physical impossibility, then the federal law applies. The second type of conflict preemption occurs when the state law frustrates the purposes and objectives of the federal statute, a slightly broader test. So this is our background, our little primer on preemption. And so let's talk about the Federal Arbitration Act. The Federal Arbitration Act, prior to the enactment of the FAA, states had been regulating arbitration. So states were regulating arbitration before the federal government was regulating arbitration, which is important in a preemption analysis. Notably, New York and New Jersey had passed state regulations in the early 1920s. The Federal Arbitration Act is explicitly patterned on the New York Act, on the New York Arbitration Act. This was an act that was brought into place by the business community. The business community was having a very difficult time having agreements to arbitrate enforced. Harkening back to everybody's first year contracts class, agreements to arbitrate were considered executory contracts. What that means is we have an obligation to do something in the future, and if one of us breaches an obligation to do something in the future, there were no damages. And so courts were not enforcing agreements to arbitrate. They found them to be executory contracts with no damages. In addition, there was some jealousy on the parts of the courts, both federal and state courts, and they did not like arbitrators coming in and resolving disputes. So this was backed by the business community, by the Chamber of Commerce, by the ABA sections dealing with business, and it was heavily lobbied. There were two goals of the enactors of the FAA. The first was to make agreements to arbitrate specifically enforceable. They wanted to be able to enforce an agreement to arbitrate so it was not considered an executory contract. The second piece that the FAA was concerned about, this is less of a problem in the issue of preemption, but at the end of an arbitration, an arbitrator issues something called an award. We call it an award, not a judgment. And the drafters wanted to be able to make these awards enforceable as if they were court judgments. So let's take a look at the FAA in particular. And so the first thing to note about the FAA is it makes arbitration agreements specifically enforceable. The second thing is that under sections 3 and 4, we have a federal court limitation, and federal courts can order arbitration. Later in the Act, under sections 9, 10, and 11, federal courts can confirm, vacate, or modify awards. Importantly, state law is specifically incorporated. It's incorporated in Section 2. In Section 2, this is our kind of meat and potatoes of the FAA. A written provision in a contract evidence in commerce to settle a contract or a dispute by arbitration is specifically enforceable. This gives us our contract remedy of specific enforceability. But if we look at the bottom here, it says, save upon such grounds as exist at law or in equity for the revocation of any contract. That means state law, state contract law applies. All right, so when we look at our 3 different types of preemption, conflict preemption should apply. We have a short statute. It only does a couple of things. It doesn't so regulate a field. And there's no agency regulation. The states are highly involved. This should be a dual regulatory system. And so conflict preemption should apply. But what's happened, okay, so we've got the enactment of the FAA in 1925. Oh, this makes me shudder. 1938, the Erie Doctrine was established. This kind of throws our arbitration law into question because the Erie Doctrine said that in cases of diversity, federal procedural law applies while state substantive law applies. There was a question then about where the Arbitration Act fell. In 1956, in a case called Bernhardt, there was some suggestion that arbitration might be substantive law that applies in federal diversity cases. In 1967, the Prima Paint case, notably noted for many other arbitration principles, but said that in cases of diversity, the FAA applies because of the discussion of interstate commerce that is in Section 2. 1984 comes along, and this is where preemption comes in. In 1984, the Federal Arbitration Act has been in effect for about 60 years, and this is the first time that the court says that the Federal Arbitration Act is substantive federal law that has the ability to displace state law to the contrary. This was a big change. In the 1990s, we see a gradual expansion of FAA preemption. States are seeing states can't regulate arbitration in order to protect consumers. States who want to regulate and say arbitration agreements have to be in capital letters, red font, first page of a contract. All of these types of state regulations are being preempted. In addition, certain states wanted to make certain arbitration agreements unenforceable, notably agreements in the consumer context, and they could no longer do that. The idea of preemption really came to a head in the 2011 case of AT&T versus Concepcion, which some of you might be familiar with. This was a case involving individuals who wanted to arbitrate, have a class action arbitration relating to their cell phone contracts. And in AT&T versus Concepcion, the court had to consider whether or not a California state law would be preempted. The California state law said that if a certain test is met, a class action waiver is unenforceable. And that class action waiver could occur in either arbitration or it could occur in litigation. Notably, that California law did not invalidate an agreement to arbitrate, but only in agreement to waive a class action, right to a class action. Now under FAA Section 2, FAA Section 2 says agreements to arbitrate have to be valid. And contract law applies. General contract law applies. But what the court did in Concepcion was to say that it preempted a California law that invalidated class waivers, not arbitration agreements, class waivers, and it did so by saying that the Concepcion test, which was a test based on general unconscionability law, that general unconscionability law was preempted. And so when I look at the Concepcion test and I look at the decision in Concepcion, I have to conclude that we're not talking about conflict preemption anymore. Because if it were conflict preemption, well, then the California law would have to stand, because the California law validated agreements to arbitrate. Sure, it had some discussion about whether a class action's okay, but it said that it validated agreements to arbitrate, and this was a test under general unconscionability law, which is specifically written into Section 2. So I don't think conflict preemption is actually applying. And the Supreme Court went so far as to say that that preemption applied here because the state law, notably the California decision, had an impact, had a kind of a disparate impact on arbitration. And so that's why I call this test the impact preemption test. Again, it's not conflict preemption because we no longer need a conflict to find that a state law is preempted. It's contrary to the plain language of Section 2. Again, no conflict is required. And now this savings clause, that last clause of Section 2, no longer seems to be relevant. Because if you can preempt an unconscionability test, well, unconscionability is a general contract offense that would otherwise apply. I'm going to wrap up here by talking about what's wrong with this. And I think that there's a lot of concern, particularly in the area of federalism and in the area of contract. Our federalism concerns say that, and the reason we have preemption, it's actually a two-sided coin. On the one hand, we're the Supreme Court, or the Constitution has said that federal law is supreme. But the flip side of that is that what is not legislated by federal regulatory, or by the federal government and regulatory systems, belongs with the states. And when we look at FAA Section 2, It's the only section that applies to the states. It doesn't legislate much. It only says that states cannot make arbitration agreements unenforceable. There's lots of things that states could do. States could regulate where the arbitration occurs, discovery, arbitrator qualifications, arbitrator ethics. None of these are covered by the FAA and presumably would fall within the realm of state authority. Unfortunately, under our Concepcion test, our impact test, all of these statutes have an impact. They'll have an impact on arbitration and would be theoretically preempted by the Federal Arbitration Act. In addition, there's some question then about, what arbitration is, whether or not parties have the ability to contract for things that would otherwise be preempted. And so I think our contract principles and the freedom to contract, which has been kind of treasured in arbitration law, I think is up for some questions. And I think that the way to fix the problem, I think it can only be done at the Supreme Court. Politically, Congress has not been interested in amending the FAA. Congress has tried, has never been successful. But I think that the Supreme Court, who admittedly got us into this mess, has to be the one to get us out of this mess. And I think that the only way they can do it is by issuing a ruling specifically noting that conflict preemption applies and kind of return to a traditional conflict preemption analysis. And so with that, I thank you all for your time and your attendance.